Here's the thing. I'm not sending him to lifetime recovery. He is going to safety, or either if felony drug court accepts him, he can be at felony drug court, but he is not going back to lifetime recovery. All right. Court is going to call 2022 CR 8453, State of Texas versus Mark Daniel Lewis. Can I have parties announced for the record for the state? Defense.
I'm here, Memorial, Your Honor.
And are you Mr. Lewis?
Yes, Your Honor, I am.
All right, Mr. Lewis, did you review the document counsel, you're on this side.
Sorry, Judge.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Mark Daniel Lewis who was placed on community supervision in 2022 CR 8453 for the offense of unlawfully carrying a weapon with a felony conviction on January 13, 2023 for a term of 10 years? Is that you?
Yes, Your Honor.
State.
Violated condition number 4 in Bear County, Texas. The defendant, Mark Daniel Lewis, did then and there fail to report to the supervision officer as directed for the months of October and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, state waives all the violations.
No objections.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 6 years in the prison?
Yes, Your Honor, I do.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor, I do.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, I think that the state's gonna make one recommendation and the defense is gonna request something else.
All right.
But the state is requesting state ISF followed by gang/ISP, and then to hold GPS and SOMU in abeyance.
All right. And defense, what are you requesting?
Judge, couple of things. Mr. Lewis understands the seriousness of what he's facing, Judge. In the state ISF, my understanding is where he got into trouble before, correct?
Yes.
And so he was in lifetime recovery, Judge. That's what he's requesting the court to give him the opportunity to prove himself, get back on treatment with lifetime recovery. Judge, I also have a letter from a Mr. Juan Trejo attesting to Mark's character, Judge. I don't know if you want to see that or not.
Oh, sure.
Okay.
Thank you. Thank you. So here's my question. I remember him. He's been before me previously, and previously it was a violation of 15G. He said that there were issues with ISF. I believe he said, I think either people were doing drugs or something else was going on in treatment. And, or either, no, someone was trying to fight someone, or they had Fight Club at the ISF. And I said, okay, we're going to check into that. And then what I ordered after he pled true to violation of 15G, I denied the motion, and it was to alternate mean conditions, and he was supposed to go to lifetime recovery. And people, it seems, are leaving lifetime recovery without telling me and leaving without my permission. So we need to start with 1, why did he leave lifetime recovery? And 2, why shouldn't I revoke him and send him to prison? So that's where I am.
If I can, I'll have
Sure.
to answer the first question.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Mark Lewis.
All right.
Mr. Lewis, if you can tell the court why you left lifetime recovery the first time, sir.
I had gotten placed on a zero tolerance contract with my counselor.
Mhm.
I was sent there by yourself, Your Honor, for a period of the 3-month program, and I was 2 weeks away from completion when placed on a zero contact order because somebody there had left his cell phone and they assumed it was mine and it wasn't, but that's beyond the point. I was on a zero tolerance order, and then I gotten in trouble, and somebody was cutting hair there, and they were cutting my hair, and they came in and said they're gonna write both of us up, and I took that to mean that they were going to violate the zero tolerance order. So I jumped to conclusions, and and I reacted wrong, and I left. I have no other excuse besides that, no other reason. That's what happened, and that's why that did happen. But I was doing the program, and I was 2 weeks from completion when all that happened, and everything just,
And what drugs have you been using since we have not seen you?
honestly, I got back on IV usage of methamphetamine. I gotten really bad, like within 2 weeks of.
Oh, no, I can tell by your appearance.
Yes, ma'am. I gotten really bad within 2 weeks of there, and I really wanted to. I had found myself. I lost it.
All right, so here's the thing. I'm not sending him to lifetime recovery. He is going to safety, or either if felony drug court accepts him, he can be at felony drug court, but he is not going back to lifetime recovery. So those are his choices.
Judge, I would suggest that we go to safety first and give him the opportunity to go into treatment and get that done, Judge.
All right, anything else from either side? All right. Violation of condition number 4 is true. I'm going to deny the motion, alter and amend conditions to include safety. And we can refer him to felony drug court. I don't think they're going to accept him if there's a gang issue with him. He's to remain in custody until transferred to safety or felony drug court.
Your Honor, if he does not qualify for safety due to his sex offender registration, would the court consider state ISF again?
All right.
And Judge, I'm checking on that with our coordinator for safety to find out if they'll take him, if it's just registration and not the current offense.
Okay, so we'll do safety or felony drug court. If for some reason neither of those places will take him, we'll bring him back here and I'll consider something else. And he's to remain in custody until transfer. And there is going to be GPS partial for treatment, any probation visits, and work only. If you come back here again, your fault, somebody else's fault, what's going to end up happening is they're going to file a motion to revoke, and you're looking up to 6 years in prison. And this tier thing, not going to work.
And Judge, I did confirm they will not accept him at safety due to his registration requirements.
All right, we'll see if felony drug court will take him. If they do not, then, well, so you all want to come back. If felony drug court does not accept him, then state ISF, that's cognitive and substance abuse.
I only do one track.
All right, substance abuse track then. All right, is there anything else?
Not for that, Your Honor. Thank you very much.
You're welcome.
Maybe it's you, Your Honor?
Yes. Court is calling 2024 CR 2759, State of Texas versus David Villarreal. Can I have parties announced for the record for the state? Defense? And are you Mr. Villarreal?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Villarreal, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? All right. Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail facility. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $500 fine and the state is recommending deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
State?
Yes, Your Honor.
Defense?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation and 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections.
All right, state, you may be excused. Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of evidence. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We can.
Anything you wish to say on behalf of your client?
Your Honor, he's just been very cooperative and very helpful in every way, and I think he will do great on probation.
All right, Mr. Villarreal, are you employed?
Not at this moment.
All right. When's the last time you had employment?
I believe about a year ago.
All right, so how you been supporting yourself?
I do yard work, so I've been doing side job, I guess.
All right, is there a reason you don't have employment?
No, there's not. I was waiting to get my driver's license back. I got my driver's license, so I'm acting now. I'm waiting for my social security card now.
All right. Are you living with anyone?
My sister.
Do you have any children?
Yes,
How many?
5.
What are their ages?
24, 18, 13, and 16.
All right, that's 4.
Yeah, I have another 18-year-old.
All right, so how often have you been using?
I have.
All right, if you drug tested today, what are the results going to be? And there's somebody here to drug test you.
I'm pretty sure I'll come out ready for marijuana.
All right, what else?
Let's see.
Oh, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 120 sober support meetings and 120 days. There's to be a TAP evaluation out of custody. If TAP recommends inpatient treatment, we'll start with outpatient treatment. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be 120 hours of community service restitution. The court is going to order parenting classes. Once you complete parenting classes, that will be deemed satisfied. There's to be field visits, one time per month for 4 months. And thereafter at probation's discretion. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? I mean, is there a class you need? Is there something you need from the court in order to, not pick up any new cases? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. And this court to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as though your probation officer is not helping you or they haven't addressed the issue you have, you can always come back to court. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, Judge.
Good. Thanks, Ms. Bill. Alvoy Todd. Alvoy Todd.
I'm up here, sir.
Hello, Mr. Todd.
Oh,
How are you doing?
no, great.
Okay. All right, so today is your plea deadline date. Is there an agreement or a request for jury trial?
Request for jury trial, Your Honor.
All right, Ms. Ferguson, I need a jury trial. It's probably 2 days.
Family violence or
It's
CTV?
criminal trial division.
We can do it on the phone.
All right, we'll bring you back on,
Impact court, judge.
all right, we're gonna bring you back on August 12th and you'll be in impact court. All right, so you'll be brought over dressed in whatever clothing you were arrested in. If you wish to be attired in different clothing, you'll need to do a clothing exchange. And counsel, if there's an issue with the clothing exchange, just let the court know and we'll see if we can help expedite that.
Excellent. Thank you, Judge. I appreciate it.
All right, thank you. Do you have any questions? All right, thank you.
If I could be excused, Your Honor.
Yes,
Have a good one.
you too.
August 12th.
Court is calling 2024 CR 3504, State of Texas versus Renee Sines. Can I have parties announced for the record for the state? Defense?
Louis Martinez on behalf of Mr. Science.
All right, this hearing was scheduled at 9 a.m. It is now 10:32 a.m. Your client has not appeared. Deputy Laura, did you make an announcement for Mr. Sines?
Yes, Your Honor, I did. He is not in the hallway.
All right, state.
State would ask for bond forfeiture.
All right. The bond forfeiture will be granted. Your client will be remanded without bond. If he makes an appearance, the court will reconsider.
Yes, Your Honor, thank you.
You're welcome.
Louis Martinez.
Yes, I'm just making a run back on this, whatever didn't announce this morning. Some of the judge from the main financial, I'm confused because it looks like you hired Russell Mitchell on all these cases. His Odyssey system. Really? There should have already been a judge's warrant out on him anyway in this case, so. Anyway. I'm trying to figure out if Russell is what he represents him or not. I don't know if you can help me.
Ernest Mora. Ernest Mora. Let me see what page he is on.
He's on page 4, Judge.
Thank you.
Mhm.
Page 3. All right, thank you.
No, I'm appointed. But when we looked on one of the cases on 6/17, on an unindicted case, a nightmare unindicted case, I saw that there was a notice from Ken filed by Russell Mitchell. That's why I can't read it on that, but the secretary showing the pronunciation, you know, I eventually. I'll point it out. But look, that's why I'm confused. Honestly, might have just picked Russell up as a higher counsel.
Yeah.
I think I was already on the nightmare.
No, no, correct, but honestly, we have to, just to make sure that you are.
Okay, that's why I picked up Russell. So it's showing retained on the previous cases.
She's just trying to.
Okay, good. That seems to explain it. So no judge had issued judge's warrants on him on the two other cases.
Yeah. Yeah. Mitchell.
I know Russell had represented him before, so that's probably why his name just came up again. I'm gonna find- He's got the case. He's been a fugitive for a little while now. Looking at approach.
Yes.
I think we figured it out. There was some confusion. Odyssey still picks up Russell as retained counsel, but those are from previous representation.
Okay.
So it's been updated not to have me as his lawyer on. There's two unindicted and one indicted case. And previous to today, there was already judge's warrants out for him on it.
All right. And is there a judge's warrant on the 9524 case?
The indicted case is set today, the possession case, I think.
Yes.
There's a DWI that's still awaiting indictment and another drug case. That's awaiting indictment, I think.
Okay. And so on this case, it's going to be a judge's warrant. If there hasn't been one already in place, and he'll be remanded without bond.
Okay.
And I see on the docket sheet that he's had 2 previous no-shows.
This is the one that I've been talking to you about.
Yes. All right, we're going to go on the record. Court is calling 2023 CR 9524, State of Texas versus Anis Mora for the state
Daniel S. Park, State Executive.
defense.
Eddie Garcia.
All right, this hearing was scheduled at 9 a.m. It is now 10:38 a.m. On this case, your client has had 2 previous no-shows on April 2nd and also on April 15th. Have you had any contact with your client?
None, Your Honor.
State?
State would ask for a bond forfeiture.
All right, the court is going to issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you.
All right, thank you. It was Ernest Mora, Mora. Eddie Garcia. You're welcome.
A second.
Let's do it.
This night.
Joaquin Mendez. Joaquin Mendez. Could I see the files on Joaquin Mendez, please?
Yes.
Ruben Gonzalez.
Judge.
Dennis Johnson. Fred Meneses.
We took him into custody, Judge.
All right. All right, thank you. Could I see that file on Fred Meneses, please? Araceli Robles. Reynaldo Matos. Alberto Hernandez. If you come forward. All right, where are we on this case? Discovery. Where are we on discovery?
I believe discovery is complete, Your Honor. Danielle Cranberg. Cranberg, Cranberg.
Oh, and we're not on the record. Okay. All right. So all discovery is complete. Has an offer been tendered?
Yes, Judge, we just received one today.
All right, how old are you, sir?
52 months.
All right, Ms. Ferguson, you can reset this for 3 weeks for a plea deadline date?
Yes, sir.
Okay. All right, thank you.
Thank you, Judge.
Once you sign the reset form, you're excused.
So July 18th then?
Yes. Can you mute us for a moment, please? The party's ready on Joshua McKee.
Yes.
Is your client here?
He's in Houston, Judge, under house arrest.
So is he on here by?
No, I just filed it. I didn't know if, since it's agreed to order, if he needed to be present or not.
Yes.
Okay.
So.
Can we get it set tomorrow for Zoom or?
Sure.
Okay.
All right.
Is it the same Zoom as always?
Yes.
Okay, I'll do that. Thank you, Judge.
You're welcome. Miriam Padron.
Hi, Judge.
Morning. So we're here for sentencing?
Yes, ma'am. I think to help remind the court, you propose an alternative means of serving the sentence by doing it on full house arrest,
Yes.
and Mr. Padron would like to do that.
All right, state. Oh, no problem. All right, the court is calling 2024 CR 1908, State of Texas versus Miriam Patron Martinez. Can I have parties announced for the record for the state, for the defense?
Carl Alexander for Mr. Padron.
And are you Miss Patron Martinez?
Yes, Your Honor.
All right, we were here and the defendant entered a plea to the less included offense of obstruction of a highway as a class B misdemeanor. The defendant entered a plea of guilty. The court found the defendant guilty. And according to the plea bargain agreement, punishment was to be assessed at 60 days in the Bexar County Jail with 1 year driver's license suspension. Both parties agreed that she could consider doing full house arrest as opposed to going to the Bexar County Jail. The reason being is that there are issues at the Bexar County Jail, health issues, and also because there was no one to
take care of personal things she needed taken care of at home. Is that correct?
Yes, Your Honor.
And neither party had an objection to that. And I believe you had to confer with your client concerning that.
Yes, ma'am. We had to make sure she had the finances in order, because of what the cost is associated with the monitor. As well as make sure that she understood the parameters of that. And she was okay with it. She's elected to go along with that.
All right. Sir, any?
Carl Alexander.
All right. Then, as previously stated, on June 3rd, the court is finding you guilty. The Class B misdemeanor of obstruction of a highway in lieu of 60 days in the Bear County Jail. The court will sentence you without objection to 60 days full house arrest. And there's to be a 1-year driver's license suspension. You are aware that with full house arrest GPS, what that means is that you're not allowed to leave your home for any errands or anything of that nature. You understand?
Yes, ma'am.
And you do understand with a 60 days house arrest on GPS, that's probably a longer sentence than you would have had to serve at the Bear County Jail.
Yes, ma'am.
All right. So that'll be full house arrest on GPS. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. And counsel, if you remain in court, we're going to have to see with the Bear County Jail the placement of the GPS.
Yes.
And she may need to actually physically go to the Bear County Jail. And when I say physically go there, on Kamal Street, and they will fit you there with GPS. So just remain in the courtroom and we'll see what's the best way to accomplish that goal.
Yes, ma'am.
All right. Is there anything else from either side?
There you are.
All right. Thank you. Just remain in the courtroom. Thank you. You may be excused.
What?
Right. It's not needed. She'll be released today. Yes, no, she's not going to the Bear County Jail.
She's gonna go, we're gonna take her.
No, she's gonna go herself. Yes.
I'll show you
You gonna take her?
that. The ride's gonna take-
But what we're gonna do is counsel, you're gonna call over to the Bear County Jail now.
Oh, okay.
Deputy Laura, they may have the number, and we're gonna see specifically when she needs to report to have the GPS placed on. If that is not done, a warrant's gonna be issued for you, and you're gonna be serving your time at the Bear County Jail. Do you understand?
Yes.
All right, so just have a seat on the front row on this side, and we'll see about that. Court is calling 2018 CR 9930, State of Texas versus Fernando Serrato. Could I have parties announced for the record for the state, for the defense?
Joseph Uphelt.
And are you Mr. Serrato?
Yes, ma'am.
Yes. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Fernando Serrato who was placed on deferred adjudication in 2018 CR 9930 for the offense of burglary of a habitation force on April 17, 2019 for a period of 8 years? Is that you?
Yes, ma'am.
State? Oh, and I'm sorry. Also, did you review the state supplemental motion to enter adjudication of guilt and revoke community supervision?
Yes, ma'am.
All right, state, what allegations are you proceeding on?
Violation of condition number 13, Your Honor.
All right. Mr. Serrato, did you review violation number 13 with your attorney?
Yes, ma'am.
State is alleging that on or about the 11th day of February 2024 in Bear County, Texas, the defendant Fernando Serrato did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13. How do you plead to that? True or not true?
True.
State, is that the only allegation you're proceeding on?
Waive and abandon the remainder, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 13?
Yes, ma'am.
Court will find violation of condition number 13 true. Is there proposed agreement?
There is not an agreement, Your Honor.
All right, state, what are you requesting?
Guilt supervision, adjudicate guilt, assess punishment for 4 years. Finding.
We would respectfully request the minimum, Your Honor, 2 years. And if I may, Mr. Serrato is not a citizen. He has been previously deported. After conferring with Justin Tullius at our last setting on June 3rd, at length and in great detail regarding Mr. Serrato's situation, any possible defenses, et cetera. Mr. Tullius conferred with him, gave him certain bits of information and counseling advice. Mr. Serrato currently has a federal detainer on him for from ICE. And so what we're requesting, Your Honor, is to revoke him and sentence him a minimum 2 years. That way he would get transferred over to the federal Department of Justice sooner and onto, in essence, their responsibility.
All right. Probation, has he done anything since he's been on probation?
No, Your Honor. Probation is recommending revocation. He was placed on probation April 17th of 2019, and he was transferred to ICE custody, and he was transferred to Honduras September 6th of 2019. We informed the court via supplemental report that he was deported, and February 11th, 2024, he had the 2 additional cases, and we were unaware when he returned back to Bexar County.
All right, so correct me if I'm wrong. My understanding is he was deported
Correct, Your Honor.
and he came back to the United States.
Correct, Your Honor.
And I'm assuming, if I'm wrong, correct me, that he came back illegally.
Correct, Your Honor.
And then he came back and committed a new offense.
Correct, Your Honor.
And I understand driving without a license or with an invalid license. I understand we're not in felony territory.
Correct, Your Honor.
All right, this is what the court is going to do. The court is going to find you guilty and find 13 true. The court is going to sentence you to 8 years in the prison, give you credit for any time served, and there's to be no re-entry into the United States. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, you do have a limited right to appeal. If that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes,
All right, do not come back unless you're back legally. You understand?
yes, ma'am.
All right, good luck to you.
May I be excused, Judge?
Yes.
Thank you.
All right, Nick Gomez.
Good morning, Judge. May I approach?
Yes.
I've been court appointed to represent Mr. Gomez and
Where is he?
he's in custody.
All right, come down, Mr. Gomez. All right, so when were you appointed?
It's been several months, probably 6 months now, Judge.
All right, so today is his plea deadline date.
Right, and Your Honor, we are in the process of negotiations, but I'm set in impact court right now. I think I'm number 2 and judge is bringing a jury up in about 15 minutes. So I need to hustle back and see if it's my case. I've already texted the attorney on the number 1 to find out his status. I'm asking if we can recall him for Thursday, because I do believe my trial in that impact felony court should only be a couple days. And then we can try to settle it. The DA is still reviewing his file for our counteroffer request. But I do believe we're near reaching an agreement.
All right, Ms. Ferguson, recall this for June 27th. There'll be no further extensions of a plea deadline date. If you all reach agreement on that date, the court will accept a plea. If you all do not, then what will end up happening is you're going to be scheduled for jury trial and the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Deputy Lauren, Mr. Gomez can go back. Joshua Estrada. Hello.
Good morning.
Good morning. All right, so today is plea deadline date. Where are we?
I'm sorry, I thought this was not a plea deadline.
Judge, we didn't have an offer till today, so
Okay. All
we've
right.
just gotten an offer today, and then district attorney's gonna reach out to one other person to see if we can amend that offer, so.
All right, how old are you?
21.
All right, Ms. Ferguson, set this for the end of July for a plea deadline date, please. You're welcome. It's a Monday.
Yeah.
Judge, I think the 29th of July and the fifth, I'm out. I'm back on the 12th, so 22nd or August 5th is when I'm available.
All right. He's young. Ms. Ferguson,
Yes, ma'am.
put this on August 5th for their plea deadline date.
Yes.
The 12th, Judge, I'm out the 5th.
Oh, you're out the
The
5th.
29th and the 5th, I'm out. But I'm back the 12th and I'm happy to address it and be ready to do what I need to do then.
All right, Norma, put it on August 12th.
Yes, ma'am.
Is that good?
That's perfect, Judge. I'm sorry.
All right, no problem.
I try not to be out often, but
No, you need you need relaxation, get away a little bit.
that's when Memo gets a break, so I
Yeah.
hop in there.
All right. All right. So once you sign the reset form, you're excused.
Thank you, Judge. Good to
You're
see you.
welcome. You too.